please state your name and affiliation, and perhaps, as we were doing with me, we'll take 2 or 3 questions and then invite the panelists to comment on those questions.
Thank you. My name is Mohamed El Abdallah. I'm the Director of Syria Justice and Accountability Center. I have a couple of comments. First of all, I want to mention Libya as a case with the national and the international. Why look to the Bosnia, where there's like 20 years back? There's a conflict here, and there's a tension clearly between the nationals and the internationals. And same case is going to happen in Syria, because part of this is not really related to which laws to be applied, but more to the patriotism inside Syria. They want to trial Assad inside or sue Assad inside Syria, and because there's kind of hostility against the international community who did nothing to help Syria, and why at the end they will get the tribunal out of the country. But I want to go back. Would the transitional justice only have tension with the rule of law, or it's going to hijack the international rule of law thing? Because from one side, the transitional justice concept is mainly about how much justice you can give and how much sacrifice of the justice you can give to make in favor of the peace building or the transition. And if you're sacrificing some of the perfect justice, basically the entire concept of rule of law, of perfect justice, is gone. And why people should believe in justice later after they see perpetrators went off the trial, or they run out, they just gone away with their crimes, because of the transition. Because we cannot put everybody behind bars, and because we cannot sue 10,000 people like Libyan case. And and the second tension is why the international criminal mechanisms or criminal justice mechanisms is too long. It's taking a lot of time. And if you cannot wait. If you wait, people will take revenge. They go themselves and try to get their rights back. And if you do it quickly, you're sacrificing or abusing the due process. So basically, it's the challenge of get it right. And back to the international versus domestic, people don't like the international mechanisms because it's very long and it's taking their cases from their hands or from their country, but domestically they're not capable to do it themselves. And even building the capacity of the people for the role of law is going to focus mainly on the domestic laws and the courts who's suffering of massive backlog of cases and not capable of doing it. So we're just running with this circle of basically chicken and egg. Who's first and how to start it and how to get it right. Thank you.
Thank you. Other questions?
My name is Tiffany Davidson. I'm with the Department of Homeland Security. I wanted to ask about what to do about the tricky problem of the military in these transitional situations and also rule of law situations, because as much as you'd like to put them in a box and draft some sort of law that's posse comitatus-like, I think what we've seen in a lot of situations is that the public actually prefers the military in many instances to the civilian leadership that was in charge. So if you could just address some principles of what works and what doesn't in this transitional justice and rule of law project field relating to what to do about the military.
We start with those. Anyone want to jump in?
Well, I'll jump in with partial answers, I think. On the challenge of international justice, I think you're absolutely right, and this is the nub of the problem. And your comments really underscored for me another point that is really critical to successful transitional justice and transitional justice that contributes to rule of law, and that is not just that it be fair and in accordance with international standards, that it be swift, relatively swift, and importantly that it be seen as such. So there's a huge communications challenge around transitional justice, that it needs to be effectively communicated to the local populations, the affected populations. And we've seen lots of examples. The Milosevic trial, I think, stands out as an example of a process that can be hijacked and really undermine the notion of transitional justice and rule of law. And we've seen examples in other contexts where a very effective outreach and communication strategy around transitional justice has had much more positive effects. So that's another critical element here. On the question of military, that is a very good question, not an area of my particular expertise. I would think, however, that there are important steps to be taken in terms of our own military-to-military training and exchanges, and imparting to military counterparts who may be taking on a leadership role in countries in transition about doing so in a manner that upholds fundamental rights, is consistent with notions of military justice, civilian control of military, and that sort of thing. So I would think that that would be an important component of supporting that aspect of rule of law in these contexts.
Thank you.
Yeah. Well, I'm not very familiar with Syria, but I can relate to the challenges that you are referring to. And maybe I'll say a few words about what you say about transitional justice being what's the fair balance you'll do in terms of delivering justice and the sacrifice that you'll do in actually removing maybe certain measure of justice. On that, I'll say perhaps that transitional justice is a strategy that a context produces. So it depends on what you put in to get out. So it all depends also on there are certainly a lot of elements to that factor in, but if it is a strategy and if we agree that from lesson learned, it is a process that is context specific, it's a process that's owned by the people, it's a context that is put in place to alleviate the suffering of the victims, restore credibility in state institutions, and allow non-repetition, I think it will be maybe counterproductive to consider it as something not correct if you were part of the process of designing it. And I think that's quite very important. And as I said before, the problem now is that we need to define the credibility of transitional justice because quite often it appears as a soft concept. But I believe rather that it's a strategy that you get given what you've put in to process that strategy.
Just a quick to take my moderator hat off on the Syria issues. I think something that really underpins a lot of the work that we do is that the need to really involve victims and communities in making decisions in relation to transitional justice. And I think that issue is to victims seeing perpetrators walking around. Really, transitional justice is a negotiation. It's a negotiation of what you can do with limited resources, limited political will, and with perpetrators still in power, how you can negotiate such that a certain number of those perpetrators do see accountability and such that victims, as Andrew says, have restorative or reparative justice. But if that negotiation happens in a way that is either by the international community or is by the political elite, then it's of course inevitable that those people who really should benefit don't see themselves as stakeholders in the outcome of that negotiation. So the negotiation has to place victims insofar as possible at the center, so that when it inevitably produces a very, very imperfect result, they see that as something that they understand and, as Betsy says, that is well communicated.
Mohamed, I'd like to address your question, not directly, but use it to talk about something very much related, which you'll recall we talked about when we were together in Istanbul with our colleagues from Freedom House. How do we do transitional justice in non-transition environments or pre-transition environments? How do we do rule of law for that matter? And let me take the transitional justice one, because one way that we have been trying to deal with situations like Syria, et cetera, as you well know, is through the documentation. So it's training and documentation, and there's other things. But first of all, ABA ROLI has recently been involved in this effort in actually compiling the evidence or the information, the data, and the evidence that can be fed into an accountability process, either at the international level or at domestic. So I think that I would just say, for those of you wondering what can we do in situations like that, that's sort of what we are doing. And an important way of going about doing this is to, when gathering that information, and commissions of inquiry do this as well, we do so in a way that it can actually go towards establishing modes of liability, command responsibility, and other forms of responsibility, direct responsibility, so that the prosecutions can actually be much more efficient. And then just lastly, on the military issue, I'm not exactly sure how to answer that, but to the extent that militaries are calling the shots in transition contexts, I think that again, everything is context specific, but I think you have some significant justice issues there depending on who in the military. But it just raises this issue of amnesties, which we haven't really touched on, that again creates lots of tension, particularly in the transitional justice context, about how to pursue amnesties in a way to get people to the table or to move forward, but at the same time still keeping some commitment to accountability. And there are standards on that with the UN.
So on the military point, I'd also like to invite Olivier just to talk a little bit about the case against Amadou Sanogo, who is the former coup leader in Mali. It's an interesting case in terms of sequencing, because if you thought about June 2012, you never would have thought that you could be prosecuting Sanogo for at least a portion of his responsibility for war crimes as we sit here now. But on the other hand, it's a prosecution that is problematic because of the support that General Sanogo still has from people who supported the coup, because they saw him as somebody who was removing a political elite. So Olivier, I don't know if you have comments on sort of how it was possible to prosecute Sanogo now and what the risks are of that prosecution.
Yeah, well, it's a very interesting process of settling account for crimes that have been committed through the period of the suspension of the constitutional order in Mali that Sanogo actually triggered. And then to mention quite clearly that the crimes for which he is being prosecuted now have absolutely nothing to do with the crimes committed during the occupation in the North, not mass atrocities. It's rather the crimes that have been committed alongside the interruption of constitutional orders, the crime that has been committed against other members of the military that were removed by him and who tried to actually do a counter coup. So, but regardless, the prosecution of someone like Sanogo has been made possible through, I'll say, subtle, I would like to believe it was subtle, kind of planning to let someone who was very critical into allowing a return to constitutional order, organize democratic elections, to have a sense of political stability, and then later on maybe start to completely weakening the person and then remove him from a position where it could actually cause more harm. But the question now is, was it really a proper timing to get Sanogo? Was he weak enough to actually prosecute him, to take on him? I don't really have a clear answer on that, but facts suggest that maybe it was a little bit too early in the post-conflict situation to get someone who has garnered really a lot of support, popular support, especially from the people from below, who considered him at some point as someone who did the good thing in removing the then president. So the coup of Sanogo was not condemned in a very, unequivocal way by everyone in the country. So therefore, how he is being treated is actually subject to controversy.
Thank you. Other questions? If you can go up to the microphones, thank you.
Hi, Ryan Sudo from the Tahrir Institute for Middle East Policy. We've been talking about sequencing with transitional justice and rule of law. I was wondering if I could hear a word or two about sequencing regarding elections in the context of TJ and rule of law. Thank you.
Any more questions to add to that? I have one quote that I think would maybe trigger some discussion, just from a recent book on Transitional Justice and Rule of Law Reconstruction, recommended reading for anyone at this panel, which says that in transitional societies with a handful of justice sector personnel, widespread public hostility to the idea of law, and rampant crime or disorder, a concern with selectively accounting for the crimes of an already discredited and powerless regime may in rule of law terms seem like treating a nasty knee wound while the patient suffers major organ failure. So I'm just wondering if that also triggers discussion.
Do you want to do elections? I'll take a stab at the elections question, which again, I think frustratingly, in a way, the answer is it depends. It's going to be very context specific. I think there are going to be circumstances where a transitional justice process that would extract spoilers from who might otherwise be running for office and then disrupt elections or co-opt elections, corrupt elections, and undermine a democratic process. A transitional justice process that would get them out of the way, I think could be quite important before elections. On the other hand, if you have kind of a governance vacuum and don't have a legitimate government with which to engage on transitional justice or rule of law, then and you can carry forward elections without some of those concerns, maybe through there's a lustration process or a vetting process that you manage to keep the bad actors out of the way, away from corrupting the election, then that might be the way to go. So I think it's very context specific.
I would just agree with Betsy and point to some of the situations where we saw and are seeing pressure for snap elections. So Bosnia is one. We went for elections, and still there were all sorts of violators running around, feeding into ethno-politics, which I think we're still dealing with throughout the Balkans. In Central African Republic, we're hearing push for snap elections there. Again, without really thinking through, and to fill that governance vacuum, which is so key. But again, thinking through the longer term implications of that. And this is where the politics, international politics included, really come into play with trying to balance all of these considerations. So.
I think this is quite a very good question, and maybe I will rephrase it rather when you just pose. Maybe how electoral challenges impact on designing of transitional justice model, perhaps, and how also it impacts on the timing of setting up transitional justice mechanism. I'll take Côte d'Ivoire as an example. In Côte d'Ivoire, President Ouattara campaigned or put a post-electoral a program that you will really handle crimes committed during the previous regime. And he has been 5 years in power, and very little has been done on actually addressing his electoral promises and his plan on actually addressing atrocities committed. Unfortunately, the way it has been done only by one side, by the side of those who have lost a little bit of victor's justice. And then a couple of months now from the next elections, then maybe mechanisms that he promised for over 5 years are starting to become back into the main discussions, maybe for the electoral moment only. And after the elections, going maybe to go a little bit down, and then nothing will be done. So how maybe the transitional justice discourse is manipulated into electoral moments could be a very interesting thing to discuss or to look.
Actually, I had 3 questions, but I was trying to ask a lot. But we recently launched a report about transitional justice on Syria, and what's people's perspective basically about issues like accountability, negotiated settlements, and what the refugees and IDPs expecting, and national versus international preferred trials. And the clear concern was a negotiated settlement if Assad can go away with his crimes. And that's happened, honestly, with all the due respect of the UN criteria to that. That's happened in Yemen, where President Saleh just got a clear amnesty. He killed 149 people in one day, and nothing happened there. Nobody really compensated those victims. Nobody opened an investigation. And basically, to have the negotiated settlement, you need to sacrifice the transitional justice again, because especially when you have a very politicized conflict like the Syrian one, and you might end up sacrificing the entire justice thing just to get Assad out of the equation. And here the transition process will start eventually after the end of the Assad era, but with a clear guarantees that no trials, no justice, no, I don't know how to phrase it, this transition without justice. That will be a problematic here. And the other question is, on the role of law itself, there's a de facto role of law mechanism and structure being installed now in the liberated areas in Syria. Sharia courts applying different laws, applying different kinds of, they apply the draft law of the Arab League initiative in 2004, which is combined by civil law and Sharia law, and which has never been ratified in any Arab country, but it's applicable in the liberated areas. And different extremist groups have different laws to apply on people. When the transition mechanism starts, what's the trade-offs here? How you convince those people to go back? People are thirsty for rule of law in Syria. So basically, they understand this is not a real rule of law, and they don't like it, but it's imposed on them. But there's de facto authorities here who's running these mechanisms. And afterward, it's not going to be easy to go back to the law before, because people referring to it as Assad law. And if you want to prosecute based on domestic law, lots of the international crimes being committed are not listed in the domestic penal code, so you cannot really prosecute for those. So you're running, again, in a dilemma between rule of law and transitional justice here. And one comment I had for, on general, Tunisia passed their transitional justice code within 2 years, not necessarily to wait for a couple of years. And here's where the international community can play a role, actually. Is this transitional justice law is a genuine thing, or just being to satisfy the international community's pressure on these countries to make some reform quickly? And the same thing, not the same thing happened in Egypt, and that's why we saw Shafiq running for the election in the first round of the election, and he might end up being the president of Egypt. Thank you.
There's a lot of questions there, so maybe we'll just respond to those now. Any comments?
Maybe I'll just say one thing on Tunisia, because I was a bit involved in the process of actually assisting people to be consulted on the transitional justice law that has been passed in Tunisia. After a year, I think that was enough time, I guess, for consultation with stakeholders, and also enough time to make the law owned by the people. Well, I may not be in control of other donors' kind of dynamics around the passing of that law, but I think it was necessary in Tunisia. After the quick transformation that took place, it was really unexpected that Ben Ali would go so fast. It was necessary to first maybe try to avoid that there is a witch hunt against those who were supporting the previous regime. And then, but I think Tunisia could be a very good model in terms of integrating a transitional justice strategy into one law. And I think this is why the first time that we've seen people wanting to have everything in one law, where you have provisions for prosecutions, provision for a truth commission, and provision for reparations, and provision for other reform. Is it going to work because everything is taught at the same time? I'm not quite sure. And what do you do about sequencing when you have all, everything all together? I don't know. But maybe about capturing, maybe something that I think I'm going to pick on what Andrew said before, what to do in a situation where transitional justice is difficult to actually achieve. Well, period where we could call maybe some kind of pre-transitional justice phase. Documentation is one thing that Andrew mentioned, but I think something else quite creative that could be done would be to start capturing victims' perception on actually what you want. It is very important, and I think that could actually put the debate on a different level, where you could put proportion on what really people are expecting. Right? The whole exercise is not to have a quantitative kind of data, but qualitative and reflection on the expectation of the people. It could also serve as a very good platform for the victims to feel like they are maybe given a platform to vent some of so that people are thinking of them. People are actually thinking of making them discuss how their suffering will be dealt with.
I think it's just an interesting point on your first point in terms of sort of the sacrifice of transitional justice for a peace negotiation. Mali is another interesting case there because you have peace negotiations that are happening with, for example, the Tuareg separatist groups in the north. And because of those negotiations, the government is not able or not willing to prosecute violations committed by those rebel groups, allegedly, but also they're not willing and able to prosecute violations by the Malian army, because unless they prosecute the rebel groups, everybody's going to be outraged that there's just prosecutions of the Malian army. But that doesn't necessarily mean that transitional justice is going to be sacrificed. It just means that the time isn't right now in Mali, perhaps, for those prosecutions, although hopefully we'll see them later on. And so I think a question to ask the international community, and it's a question maybe I'll pose to the panelists in a minute, is our reaction to atrocity of prosecution and accountability, is it too sort of visceral, and do we need to be a bit more patient and a bit more understanding that this is just a political exercise? And if we are more deliberate in our political analysis, can we be a bit more subtle in the way that we approach it? So my question is really what next, in the sense that we acknowledge that there are tensions, we acknowledge that it's a very imperfect relationship, albeit sometimes a positive one. So what do we need to do next to bring these two fields together?
Well, I have lots of thoughts about that, but I want to just pick up on the last point and answer the question about amnesty, and just caution also the notion that it's really an either-or as opposed to a sequencing or timing kind of question. And I think the classic example, of course, is Sierra Leone. Amnesty purported to facilitate a peace agreement which didn't last very long at all before atrocities continued, and it was really only an accountability process there that ultimately was supportive of a sustainable peace. And so to pick up on the quote, again, in the metaphor of the dying patient, I think actually it's not that the atrocities are some kind of sort of nasty wound that is distracting us, but it's actually a cancer, right? That and this comes to the timing and sequence point too. Maybe we don't need to go straight to chemotherapy today, but we certainly better attend to it and have a plan for addressing it, or it will ultimately doom our poor patient. So how do we, what's the way forward? Well, to come back to my earlier points about some of the disconnect between our communities and of communities of practice, I think there is a lot to be done about learning about for international justice types to learn about rule of law development assistance and vice versa, and understand the legal frameworks, the tools and mechanisms that we have to appreciate the time frames over which we implement these different kinds of projects, and to coordinate. It's sometimes as simple as that nasty old donor coordination that has to happen to really map out a strategy that takes advantage to the extent possible of the synergies between these two fields.
Andrew, any additions?
I do want to come back to this question of justice delayed, justice denied, and I'm glad you mentioned the Sierra Leone case, because yes, Saleh may be out there and others have yet to be held account in other contexts, but we have to have that longer term view, and eventually a David Crane may come along and actually indict or one of these people, and they have to be careful. But what do they do? What damage can they do in the meantime? So is Saleh still affecting the situation, the transition in Yemen from afar? And they have I think, a national dialogue process that got much more traction than I think was originally thought, including a dynamic or a transitional justice component. And then just related to the perception of the victims, definitely key. I'm glad that was raised. And I'd like to try to link it back to indicting and prosecuting these people well after the fact. What do the victims think about that? Did that in any way help them so long after they suffered harm? Are we really doing it for them, or are we doing it for the integrity of the international system, which I think is not to be taken lightly? And then also on the so-called liberated areas, applying a Sharia law and other forms of justice. I just note this is the legal pluralism issue. In many ways, that we can have competing norms and competing systems of justice operating in the same space that people can tap into. Again, it's not an issue. I would just caution against the legal fragmentation and how we really try to bring them into a coherent system so that there is some coordination or complementarity between these, whether these are informal and customary or Sharia courts, et cetera, and the formal courts. Where do we go next in trying to bring transitional justice and rule of law together? I'll just answer it this way very quickly. I think we should take a rights-based approach to both transitional justice and rule of law that reflects the four basic global norms to counter impunity. It's the right to truth, it's the right to justice, it's the right to reparation, and the guarantees of non-occurrence. I think to the extent that we, both in transitional justice and rule of law, think of our work both in those constructs, and we can do programming and initiatives that I think reinforce one another in those different areas, as well as, again, bring them all together. Easier said than done. So more research and analysis, Betsy.
Olivier, any thoughts on the what next?
I think for me it will be understanding the roles, the weaknesses and the strengths that transitional justice will have in the process as to upholding the rights of the victims, or the four rights that Andrew just mentioned, and how to see how we can utilize the rule of law to make transitional justice a better process and a better strategy.
Any other questions? Just one quick comment on that. I think something that we could all be better at, as certainly me personally, in terms of both rule of law and transitional justice, is really seeing ourselves as political people who need to understand the politics of the countries in which we're working. And that's not something that we receive much training on, or if we define ourselves as international lawyers, something that we necessarily know, but is critical to the work that we do. And I think, for example, Olivier in Bamako has really been able to position himself as somebody who understands the politics as well as the rule of law and transitional justice side, and our program is massively benefiting from that. Any other final comments? And then I'll perhaps, if there are none, I'll just give our panelists their final word, perhaps, each a couple of sentences on the importance, and again, just if there's any advice. Any final comments from the audience? Okay. Panelists, your last word.
Well, I'll just take Andrew's bait there on to invite all of you to tackle this problem, because I think maybe as our discussion suggests today, it's very complex, it's very context specific. We have a lot to learn. The Secretary General's statement is true at a very abstract level, but the devil is very much in the details, and we need to tease out those details, identify models for taking advantage of the synergies between rule of law and transitional justice, what works, what doesn't, what's the right sequencing, in what contexts, and that is an enormous agenda for all of us and should be a pretty exciting one to embrace.
Andrew?
I concur.
Just concur. Olivier?
Well, maybe a little bit of controversy, I think, would be good to finish. I think the problem that implementers like myself, also lawyer at the same time, find is sometimes we come with concepts that are defined, but maybe certain concepts are very difficult to be, how do I say, to be integrated in certain contexts. Like transitional justice is one of them. Certainly a term that is gaining momentum and becoming something that known by everyone, but is a term that in itself brings a lot of problems in terms of understanding and therefore in terms of implementation. A better term would have been, would have avoided people to have to be explaining all the time what is the intervention about. So maybe that's a challenge for you experts in different things. A better term would have been better for transitional justice, let alone for you if the rule of law is an easy one, maybe there could be a easy term to define the rule of law that could be understood by a woman in a village in Guinea or a Tuareg in the desert in Kidal or Tessalit.
Thank you. Well, thanks everybody for coming, and thanks especially to our panelists for participating. I think we can give them a round of applause.